Adjournment request, if any, from item number 1 to 5. From item number 1 to 5. From item number 6 to 15.
My Lord, may I request in item 12, my Lord?
Yes.
My Lord, I would like to do this matter physically before your Lordship. Lord, I'm requesting if it can be subject to your Lordship's convenience, of course, if it can be kept on the 3rd or 4th of September, my Lord.
Which matter are you mentioning?
Item 12, my Lord.
Item 12. All right. All right. You're for the petitioner.
Petitioner, my Lord.
All right. As prayed for, on behalf of the petitioner, let this matter come up for consideration on 4th of September. All right.
Obliged, obliged, my Lord.
All right.
Yeah,
Yes.
please, your lordship. My lord, I am seeking some accommodation in item number 9, my lord.
9.
9, my lord.
Yes.
Some talks are going on for out of court settlement, my lord, in the matter. If it can be taken after 3 weeks, my lord.
The land counsel for the writ petitioner submits that there is a possibility of out of court settlement. He therefore seeks an adjournment for 3 weeks. Let this matter be listed under the same heading on
11-9.
Okay.
May I please, your lordship? Lordship, with the concern from the other side, I beg to mention item number 11.
Yes.
As my senior Mr. S.K. Media out of.
as jointly prayed for, re-notify on so and so date. 3 weeks.
6
4 weeks.
16-9.
May I please, Lordship? Lordship, with the concern of other side, I beg to mention item number 10, Lordship.
Yes.
Matter may be adjourned for the Lordship.
My Lord, I'm for the respondent, my Lord. A short
Yes.
date may be fixed, my Lord.
A prayer for adjournment has been made on behalf of the petitioner. Though there is no objection by the counsel for the other side, but he insists for fixing of a date. Let this matter come up for consideration on give a date.
16-9.
Blessed.
Any other request? Daily list for admission item 1.
May please, Lordship, my lords. This representative is filed, my lord, selling the into an order, my lord. While my lord,
Yes.
my lord, while the my lord, by the impugned judgment order, my lord, my prayer has been, my lord, rejected, my
Yes.
lord. The prayer made in the repetition is that, my lord, the petitioner will duly approved by the BTC, my lord,
Yes.
for RCC training, my lord. Accordingly, state government has approved, my lord, for scheduling the time, my lord. In the meantime, my lord, BTC forwarded another list, my lord. So due to, my lord, they have been, my lord, admitted. Then we will deny to admission, my lord. Then I approach the honorable court, approach the court has, my lord. Maintain the status quo, my lord.
There has been a change in the rules. Are you aware of that?
My lord, that rule, my lord, rule 23, my lord, note,
Rules of 2023 where the qualification has been hiked.
height, my lord, but
You
they have
can go
not,
for a training only if you are a graduate.
my lord, but they have said in their affidavit, they have not on 23 rule, my lord. I have said that whatever made in the advertisement, it seems to be they have issued the advertisement on the basis of 23.
Otherwise, yours was not a process which was advertised, which was transparent in any other manner.
That's true, but not one, my lord, suggests that not required by in case of district council, my lord.
No.
The learned singular wrongly hold that the BTC is not a district council. So that's why that is not applicable. BTC is a district council, my lord.
Even otherwise.
Sub para
Forget
3 of
about
the
this
para
ground.
2 of the 6 rule, my lord.
That is one of the grounds. But otherwise, your process, the process by which you were selected was not transparent. There was no advertisement, nothing of the kind. I
No,
don't think-
my lordship may come to the rule, my lord, in the judgment itself, my lord, para 60, internal page 65 of the judgment, my lord.
Yes.
So the rule has been quoted, my lord. Lordship may come to the para 64, my lord, paragraph, page 64, paragraph 15 of the, my lord, impugned judgment, my lord.
Yes.
This is the rule, my lord, regarding, my lord, general procedure in case of, my lord, state of Assam or, my lord, actually leaving the, my lord, council area. Lordship may thereafter may come to the, my lord, the page 66, my lord, that note 1, my lord. May I read the note, my lord?
Yes.
My lord. Candidates slash deputed by other state, district council, I am hammering my lord, the district council, my lord. Public and private undertaking, enterprises, bodies and private individuals seeking admission as private candidate. 2. Uncertified recorders working against permanent vacancies and recommended by the deputy commissioner for training in the Assam Survey Training Center, educationally qualified sane man working for more than 8 years under the revenue department as selected by the director, not exceeding 5% base strictly in order of seniority, comma, need not be subject to the entrance examination, my lord. That is applicable to the 6th schedule, my lord.
Maybe, but then the process was absolutely opaque. Therefore, we do not know.
My,
And the BTC comes up with a plea that the others, I mean, those who were allowed to go for training, their process of selection was very transparent. So we go by.
I admit, my lord,
what
the
BTC
private
said.
respondent selection is a transparent, my lord. I admit that, but in case of prior to the disease of rule, my lord, that has been applicable, my lord, earlier, prior to this, my lord. Earlier, several batch has gone, my lord. But there is no selection process, but there is a, my lord, they have invited
And
applications,
we have serious doubts with respect to any future, training
my lord,
for RCC.
my lord.
I think the qualification, would be graduation, and
My
a
lord.
few would be graduate. It
If
appears.
they adopt the 23 rules, my lord, they have not adopted.
We have fixed such matters for.
When? You and then
We have fixed such matters for 12th, no? 60.
31 and 30.
Yesterday
Are
matter,
you, are you aware of that case which we have dealt with?
my lord, yesterday's matter, my lord.
He is the council. So we will hear it on that day only. Let this case be listed along with so-and-so on so-and-so date. Yes.
My lord, may I pray for, my lord, in the meantime, my lord, the private respondent may not be admitted, my lord.
No, that must continue. We'll
Because, my lord,
deal with your rights.
till, my lord, this
So that-
disposal of the reputation, my lord, this status quo has been maintained, my lord, by the authority.
Status quo. There was no reason for grant of status quo because the training had to begin from a particular date. Now they'll have to announce another date.
But that schedule is for us, not for them, my lord. They have to prepare another schedule, my lord.
Another
That
study.
schedule is for us.
We'll consider whether this training could be had under the old rules.
My
Now, because this is a precursor to the appointment as land record assistant, is it?
My
correct?
lord, even then I have to face interview, not that I passing of the immediately RCC, I will be appointed as a last one.
Try and understand what we are talking.
My lord,
Now, after the promulgation of the rules, there is some dispute whether the rules of 2023 has been notified in BTC. We
my,
will be deciding that issue on
My
that date.
my lord,
Now, if those rules have been promulgated, then all trainings have to be undergone in accordance with those rules.
my lord,
And there the qualification is graduation.
my lord.
1991, it's only higher secondary.
Higher
So
secondary,
therefore, you may have been recommended, but nothing is there on the record of BTC administration that you were, all of you,
my lord.
many of you. On the contrary, the respondents have been recommended and perhaps they should have gone for training, but for the status quo order of this court. Finally, that order was vacated. Fine, with the dismissal of your reputation.
My lord,
So you don't have a right there. We will consider whether you had a right which could be crystallized in some other training program, but not here. Once the rules of 2023 are applicable, then perhaps the
My lord.
training has to be of only such persons who are graduates. Otherwise, Lot Mandal is a post which now has been abolished. It has been renamed as land record assistant.
assistant, my lord.
Correct? So after this, it will be land record assistant and they have to do some important work for which higher secondary education would not be sufficient. We'll see it on that day
My
together.
lord, my lord.
27-8.
You would be counsel in that case, no?
My lord, I will.
27-8.
I love this, my lord.
Yes.
The
Yes,
appellant before your lordship is a medical officer. He was originally, he was in the central government, in the ESIC corporation, that is Employees Insurance Corporation. of the central government. He came to deputation under the Mizoram Health Services in 2011 for a period of 3 years, and it was extended for another 1 year. So at that time when he was about to leave and for repatriation, he was getting ready. Lordship, his wife died and he had 2 small children. So he made a request to the authorities for his absorption, if it is possible, under the Mizoram Health Services. So which was considered by the appropriate authority by fulfilling all the norms, he was absorbed. Certain regulations are there, Lordship, in respect of a particular rule, that is Rule 10, 1 and 3, that calls for direct recruitment and promotional recruitment. But there is no scope of absorption under the health services rules of Mizoram.
Unless those rules are relaxed.
Yes, that was relaxed. That was relaxed under Rule 13.
That's right.
Certain conditions had to be fulfilled. Every condition was fulfilled. And his services was required by the department for 2 purposes. He has a background of insurance activities in his parent department, and his services was undertaken by the Mizoram, and that was the precise reason why he was allowed for deputation. So he was instrumental in making this scheme, that health insurance scheme of Meghalaya, Mizoram, very successful, and he was a very competent officer. So these are the 2 grounds on which the personnel department referred the matter to the Public Service Commission for their approval. They have agreed only with a condition that he will be placed, he was in a grade 1 officer, so he will be placed at the bottom of the list. So far as writ petitioners are concerned, at that point of time, they were in grade 2. There is no competition and there is no meeting of the lines for their promotion. So in that situation, the government has consciously taken a decision to absorb him, and that was put to challenge. The learned single judge found that no record was produced regarding the reasons. That is one ground the learned single judge considered. The second ground is that there is no provision for absorptions under the Mizoram Health Services rules. And third ground, that no order, no scheme, no scope has been formulated by the Mizoram government by relaxing the rules. So it is, in case of one person, it was not a general, so no other persons would get benefit. So on these 3 grounds, my writ petition was dismissed. So I am there since 2011 till today. I am working. There is an interim protection in my favor. So that is my case. So if Lordship wants to look into these rules, this is the basic case.
Let's have the rules first.
Yes, Lordship. No prejudice has been caused to them. Page 42 is the Mizoram Health Services Rules 2009.
Where do we get the rules?
That page 42 of my paper book. Lordship will kindly come to page 43, composition of services. The services shall be divided into the following subcadres: A, general duty medical officer, GDMO subcadre. So I belong to this category, and there is subclassifications. Then 2.1, the general duty medical officer subcadre will comprise of MBBS doctors with or without additional MCA recognized PG degree diploma. Then Lordship will kindly come to 3. Each subcadre shall have the following grades: GDMO, dental surgeon, Ayush subcenters, serial number 1 grade, special grade, grade 1. So I was initially deputed in grade 1, that is the appellant, and grade 3 where grade 2 where the writ petitioners were working. So I belong to a higher category or higher grade. Then Lordship will kindly come to page 44, rule recruitment of the services. The recruitment of the services after commencement of this rule shall be the following method: 100% of the substantive post in grade 3 of CDMO, that is the entry level post, dental surgeon, Ayush. Then 2, lateral entry for specialist, public health and dental specialist subcadres can be made in grade 2 by direct recruitment through the commission as specified in schedule 3. Then lateral entry for super specialist subcadre will be made in grade 1 by direct recruitment through the commission as specified in schedule 3. So there are 3 different ways of recruitment. Then direct recruitment is given the provisions at
We are concerned with that.
yeah. Now coming to 10.
Yes.
Appointment to the service. 1 and 3 were relaxed. All appointments to the service after commencement of this rule shall be made and notified in the Gazette by the government, and no such appointment shall be made except in the manner specified in Rule 8, which I have just placed. Then 3. All appointments to the services in the higher grade of times scale of pay shall be made only by promotion in accordance with the appropriate provisions under these rules, except those holders of degree or diploma or specialties, super specialties in a particular discipline as specified in Rule 9(6) of these rules. Other things being equal, preference will be given to those persons having rural area experience. So 1 and 3 were relaxed. Now Lordship will kindly come to Rule 15, where the seniority part is there. The relative seniority of members of service appointed to a grade to the respective sub-cadres at the time of initial constitution of the service under Rule 6 shall be as obtaining on the date of commencement of these rules, provided that if seniority of any such member had not been specifically determined by these rules, the same shall be determined on the basis of the rules governing the fixation of the seniority as were applicable to the members of service prior to commencement. That is not relevant. Coming to 2B, the seniority inter se of the members of the GDMO, dental surgeon and Ayush sub-cadres shall be determined in accordance with the date of entry into the service on regular basis. This has some relevance in our case. Then 3, in case not covered by the above provisions, seniority shall be determined by the government in consultation with the commission, which has been done. So the commission opined that I should be placed at the last position in grade 1. Now coming to Rule 20. Filling of duty post by transfer on deputation, including short-term contract, notwithstanding anything contained in Rule 7, where the government is of the opinion that it is necessary or expedient to do, if may, for reasons to be recorded in writing and in consultation with the commission, fill not more than 20 duty posts in all in the grades of medical officers, senior medical officers in general duty sub-cadre, senior medical officers in public health sub-cadre, specialist in sub-cadre by transfer on deputation of suitable officers.
This deals with deputation.
Deputation.
Not absorption.
So not absorption. Now coming to 26, promotion to higher grades. Even there is no practical promotion, Lordship, but there is a scope of non-functional promotion is there. Promotion to higher grades, every promotion from lower grade to the next higher grade after commencement of these rules shall be made by the governor from the confirmed members of the service on the basis of recommendation of the commission, provided all promotions shall be made strictly as prescribed in Schedule 5 of these rules, provided further that the members of the service belonging to various sub-cadres
That's true,
except,
Mr. Saikia.
this is important, Lordship.
Anyway, yes.
This is important,
Yes.
Lordship. Provided further that the members of the service belonging to various sub-cadres except in super-time grade may be considered for non-functional promotion within their respective sub-cadre in the form of financial upgradation to the next higher grade without linkage to vacancies. This is what I am trying to harp upon. Without linkage to vacancy to ensure quality in their service after completion of 5 years in the relevant grade according to seniority subject to satisfactory performance and non-availability of vacant post for promotion. So even if they are entitled for promotion, if the post is not available, they will get all the financial benefits. That is a non-functional promotion. But I am not a barrier in their way to promotion, Lordship. I am much higher than what they are. Now coming to 30, this is the rule which has the power to give relaxation. Power of the governor to dispense with, amend, repeal, or relax any rule. Lordship will kindly take this word, any. There is not specific to only recruitment eligibility criteria or the mode of recruitment. Where the governor is satisfied that the operation of any of these rules cause undue hardship in any particular case, that is individual case, or that in the exigency of public service, my services was required, as well as for effective implementation of this rule, it is so necessary, he may dispense or relax or amend or repeal such particular rule, Rule 10 in our case, or any of the schedules to these rules to such extent and subject to such condition as may consider necessary in consultation with the commission through the Department of Personnel and Administrative Reforms from time to time, provided that the case of any person shall not be dealt with in any manner except under this Article 311 of the Constitution, as may be less favorable to him than provided by any of these rules. Provided further that any such dispensation or relaxation in any individual shall not be a precedent or binding policy of the government in any other case. So it is a standalone case, my case,
No, that's true, but this rule 30,
Rule 30.
it does not talk of any personal hardship,
Uh,
does it?
Personal hardships, exigency of public service, which I will harp upon.
Agencies of public service is with respect to the department or the government needing his services.
Yes, Lordship.
Or effective management of the department.
Lordship,
Is that correct?
absolutely, Lordship. So that is why two grounds were cited. When the personnel department sent the proposal to the public service commission, two grounds were cited. One is that personnel difficulty bereavement in his family, he has two small kids. So that is one reason. The other one is that he was very effective in implementing the
Schemes of
insurance
government.
scheme with his insurance background. So may I now place where the actual thing started, Lordship?
Yes.
That Lordship will come to. It starts from page 65. I'm sorry, Lordship, it is not 65. Yes. The first deputation order is at page 66. Then I'm coming to page 69.
First deputation was for 3 years.
3 years. Then he got 1 year's extension also. Up to 5 years, it is permissible.
Hmm.
Now, page 69. This is the Labor Department. They have said that they have no objection. Prayer for absorption of services of Mizoram Health Services from the Ministry of Labor and Employment, Government of India. So Lalthan Para, he wrote to his principal, the principal director, Health and Family Welfare Department. May I read it, Lordship?
Yes.
The second way. While I was preparing to be repatriated to my parent cadre, when my tenure expires, my wife met with a tragic accident and passed away on 10/10/2014.
But
This led to
Request has been made by whom? Not-
by the appellant. It started the process of his absorption.
Okay, okay.
This led to a complete disarray in my preparation for repatriation, and I am forced to consider applying for extension of my deputation. But on verbal query, my parent cadre, further extension shall not be considered by the ministry. Therefore, Madam, I cannot but pray for absorptions of my service in Mizoram Health Services with effect from 11/5/2015, given my dire family situation. And it may be appropriate to mention that this absorption, if considered, shall not entail creation of any new post, as I was posted against the post and pay head vacated by late Lalthan Lua. I and my family will be grateful. Now, next page. Then the principal health director of the Health and Family Welfare, Mizoram government, they wrote to the government, Lordship, to the principal. The director wrote to the principal secretary. Please find and close an application received from Lalthan Para. Further, I would like to mention that the said doctor during his deputation period under our department has rendered tireless efforts to ensure successful implementation of the both RSBY, RSBY is Rashtriya Swasthya Bima Yojana and Mizoram State Health Care Scheme. And he has been an efficient and obedient officer. Also, I personally feel that his reasons for prayer of absorptions into Mizoram is worth considering given his grave family crisis due to untimely passing of his wife. So two grounds were projected by the principal director of Health and Family Welfare Department to the government. That is the principal secretary of the department. On this, Lordship, the ESI page 71. So approval was granted. No objection for absorption of the services of so-and-so into Government of Mizoram. So the government official under Secretary of the Government of Mizoram wrote to the director ESI. Now, page 72 is the central government's approval. No objection. The Assistant Director of the Central Government Department, wrote to the Under Secretary of Mizoram Government, no objection certificate for absorption of services of Dr. R.C. Lalthanpara, Grade 1 officer into Mizoram Government. So approval was, no objection was received from his parent department. Now, the final proposal was prepared by the Personnel Department, which is in tune with the Rule 30, the relaxation rule. The commission has to be approached. So the Personnel Department sent this proposal to the Secretary, Mizoram Public Service Commission, Mizoram, prayer for absorption of Lalthanpara, Insurance Medical Officer, ESI, to the Mizoram Health Services and relaxation of MHS rules 2009 as amended. I am coming to third paragraph. The department proposed that the aforesaid officer be absorbed within GDMO subcadre against the post vacated by HB James, special grade so-and-so, who expired on 23/9/2014. Just before that, Lordship. No objections from the Employees State Insurance Corporation and comments views of the concerned service associations were also obtained in regard to the proposal by the annexer so-and-so. The government, upon careful consideration and deliberation, has decided to absorb Dr. Lalthanpara in the grade of Chief Medical Officer, so-and-so grade pay scale, and his seniority be counted with effect from the date he has been appointed on regular basis to the grade of Chief Medical Officer in his parent department, that is 19/4/2013, and he will thus be placed at the bottom of the interstate seniority list of grade 1 of GDMO subcadre. This entails relaxation of the provisions of Rule 10.1 and Rule 10.3 of the MHS Rules 2009. So this proposal was sent to Public Service Commission, and Public Service Commission gave the approval. Next page, 12 August 2015. That Lordship will not really look into page 74, that is in the vernacular. The translation copy is at page 75. I am directed to inform the below mentioned information with regard to the subject mentioned above and later referred to. The Mizoram Public Service Commission, after considering the proposal made by the government for relaxation of the relevant provisions of the recruitment rules for absorption of Dr. C. Lalthanpara, Insurance Medical Officer, ESI, Government of India, to Mizoram Health Services, has concurred the same. So the concurrence was obtained. And
Yes.
also, Lordship will see the association's no objection at page 124. So this is Office of the Mizoram Government Doctors Association. So the association, the Doctors Association also gave an.
That clearance is there.
I am, yes, Lordship, but I'm just for sake,
Yes.
I'm placing it. And therefore, on 24th of August 2015, this first notification was issued. So, okay, so is this.
That is not even there. You repeat. Really service.
So the impugned order is at page 76. In the writ petition, the impugned
Yes.
order. This is of 24th August 2015. In exercise of power conferred by Rule 30 of the Mizoram Health Services Rules, notified by so-and-so and published in the Mizoram Gazette. And in the interest of public service, the Governor of Mizoram is pleased to relax Rule 10.1 and 10.3 of the Mizoram Health Services Rules 2009 as amended for absorption of Dr. C. Lalthanpara, Chief Medical Officer of Employees State Insurance Corporation, Delhi, to grade 1 under GDMO subcadre so-and-so of the Department of Health and Family Welfare, Mizoram. This notification is in consultation with the Mizoram Public Service Commission by updated 12/8/2015. And next page is the subsequent order, the consequential order of 1st September in relaxation of so-and-so. This is the first paragraph is regarding the pay scale, etc. Sri Lalthanpara will be posted in the Director of Health Services and attached to Mizoram Health Service Care Society until further orders. He will draw his salary and pay and allowances from the appropriate head of accounts, which may be specified in Principal Director in consultation so-and-so. So this is the basic facts, Lordship. Thereafter, the representation came. And these are representation. So my case, if Lordship is now pleased to look at the judgment on what are the grounds his case was negated.
Yes.
Now, the learned single judge Lordship
Yes,
gave his findings from paragraph 11 of the impugned judgment.
yes, we
Which
were
Lord-
at paragraph 11 only.
Lordship,
Yes.
may I read
Yes,
this?
yes, yes. We have read that.
Lordship. So basically that nothing has been produced by the state respondent. That is not correct in my humble submission. May I read it? Fifth line from top. In this particular case, though the affidavit by the government and the Mizoram Public Service Commission states that Mizoram Public Service Commission was consulted with regard to the proposal for absorption of the respondent number 5, nothing has been produced by the state respondents as to why respondent number 6 has been absorbed into Mizoram Health Services.
Let's hear. Yes, all right.
The respondent have also not shown under what statutory rule, regulation, or order having the force of law, the respondent number 6, which was on deputation to the government of Mizoram, has been absorbed into the government of Mizoram in the Mizoram Health Services. So two grounds were given here. One is that no records were produced regarding the consultation with Public Service Commission of Mizoram, and the other one is that no specific rule was quoted or indicated. So to this, my response will be, Lordship, the records were there in the affidavit, whatever I have placed, Lordship, those were part of the record in the affidavit. Categorical statements are made. If the main records, the Honorable Court wanted to see, the Mizoram government would have definitely produced. In fact, during the present hearing also, at one point of time, the Mizoram Public Service, state government was directed to produce the records. But that is not recorded in any of the order, but in my presence, Lordship, the original records the Honorable Court wanted to peruse. Then number 2, that no rules, statutory rule, regulations has been placed before the Honorable Court. The impugned order itself says in exercise of power under Rule 30, that is the power of relaxation. Now, it is a different issue that whether under the power of relaxation an absorption can be made or not. That argument is not there. Then further going, Lordship, paragraph 12. The relaxation of rule specifically provides a rule may be relaxed if it causes undue hardship in a particular case or in the exigency of public service as well as for effective implementation of the rules. So 3 situations are conceived here. One is that it causes undue hardship. If we have a liberal view, Lordship, then my hardship can also come under this. Because the law settled by the Supreme Court is very clear that relaxation law provisions can be implemented or applied in a liberal manner. Number 2, for effective, in the exigency of public service. That the proposal itself indicates that he was instrumental in making the insurance scheme of Mizoram successful for his background in that particular field of operation. And three,
Effective implementation of
of the rules. For that, I would say that for that purpose only the rule has been relaxed for effective implementation. Because otherwise it will be in violation of 10.1 and 10.3 as well as Rule 8,
And the tenor of your argument says that these are not conjunctive.
Lordship.
Either of the grounds could prevail.
Absolutely, one ground is sufficient. Going further, the state respondents have not produced any documents giving the reasons as to why the respondent 6 has been absorbed into Mizoram Health Service, except stating in their affidavit that the rules have been relaxed for absorption in so-and-so for effective implementation of RSBY and MSHC scheme. So record, Lordship, I will straightway go to page 70 once more. These records were before the Honorable Court, and if the Honorable Court wanted to look into the files, then definitely an direction would have been sufficient to bring those records for during the proceedings. Page 70. This document, page 70, straightway the principal director's letter to the principal secretary of the government.
All right. Yes, Mr.
May it please your lordships. The entire argument is begging an answer, that is, a writ petitioner came to he must have a legal right. What is his legal right as a deputationist? Does a deputationist have a right of absorption in the borrowing department unless the rules of the borrowing department provides? Look, what has been relaxed is something which does not exist. Can by invoking relaxation power, you can create a provision? That is what has been done. Well, I understand.
What exactly would you see?
My submission is that,
In this provision.
my lord, there are
Relaxation.
two aspects. First, what is the right of a deputationist to seek absorption in a borrowing department? Secondly, my lord, what are the contours of this power of relaxation? These are the two aspects in my humble submission.
And that is what has been dealt with by the learned senior.
Yes.
Now you tell us.
Yes.
There may not be any special scheme of absorption of a deputationist.
Yes.
Agreed. So this is by virtue of the rules. I mean, the appointment, recruitment, promotion, all these are governed by the Mizoram Health Services rules of 2009. There is no policy frame for absorption. In that case, whether the power under Section 30, Rule 30,
Will also-
exercised by the governor
No, my
in
lord.
consultation.
No.
Why?
Power of my humble understanding, my simple understanding is power of relaxation can be invoked to relax something which exists. How can power of relaxation be invoked?
The power, you have to look at it from different angle. I mean, I'm just giving you a viewpoint. You are entitled to argue
Yes.
whatever you feel it to be legally tenable. But there are set of rules with respect to recruitment. Instead of going through that rules, the governor in his wisdom and on the basis of records, on the grounds provided in Rule 30 for either of the three grounds. One of them was very clear, that has been read out. You have also heard it. You have seen that record. So there were two schemes of the government which was very effectively handled. Then a person who was handling it died. This gentleman had to be repatriated to his parent department. He explained about his hardship. There is nothing on record to substantiate that except his statement. Agreed. But why do we differ with the decision of the government?
We should,
With
yes.
respect to relaxation of the rules? You are right. Tulsi Ram Patel, you are referring to that there should be a source of power. Now, this source of power we read under the clause of relaxation for any rule. So let there be no rule. The rule, it is sub silentio.
Yes.
The recruitment, see, any absorption would be a kind of recruitment. It would be a fresh recruitment, and therefore the person who is absorbed is put on the bottom of the ladder. So this Tulsi Ram Patel would not have exact application as we understand now. All observations, Mr. Chaudhary, are tentative.
I have followed your lordship's
So
perspective.
therefore, it is the relaxation of the rule of recruitment.
No, my lord.
Forget about any rule of absorption. we must not think now with respect to this, with respect to rule of absorption. There is no policy. There is no rule also saying, but the rules of recruitment are there.
No, my lord.
So once you relax, शिथिल करना उसको बोलते हैं, once you relax the rules for recruitment, then this, this is which is silent, that somebody has to be absorbed, which is part of the recruitment
No,
process.
Even if we do not apply Tulsiram Patel principle, my lord. Now, question is, now going per se by rule 30, whether the rule has been followed or whether the rule is so
That's right.
pervasive.
So therefore, paragraphs 11, 12 and 13, 14 of the judgment,
Yes.
they don't satisfy us.
Huh.
They don't satisfy us the reason for rejecting this.
Yes. No, my lord, there has to be a causation of hardship.
Huh.
What is that?
Causation of hardship is one
Yes.
for the exigencies of the administration. Therefore, we said that it is not conjunctive. It's not a case. It cannot be your argument that for absorption, there should be hardship plus exigencies plus effective implementation of the rules. No,
Yes.
either of them. So therefore, this power of relaxation is wide enough, but not as wide as to effect an arbitrary decision.
Exactly.
Now, the records belie this allegation of arbitrariness. Because see, he was on deputation for 3 years, extended for 1 year. One officer who was handling the yojanas and schemes, he died. The man could have gone back to his parent department, right? So, according to the rules, he could have only been on deputation. That deputation also you don't find anywhere. That deputation you don't find in the rules. There is no rules with respect to deputation would be absent everywhere.
No. Some rules provide, my lord. Some rule. No, my lord, that's why.
With respect to the decision of the government, we have followed that.
No,
Many
no.
a times,
Now,
most-
I'll place two
most
judgment,
of
my
your
lord.
employees,
Yes.
most of your employees,
Yes.
erstwhile employees of the Assam government,
Yes.
they have been deputed in
Yes.
the public sector undertakings where they have been absorbed. With the absorption, if it is on a higher pay scale, that's a fresh recruitment. Otherwise, the period continues.
On the scope of deputation and absorption, well, I'll place two judgment, then I'll deal with your lordship, I mean, few. I don't know, na? 1976, 4 SCC 543. My lord, my submission would be, he has got no legal right. I am at the root. To that, I'll make my submission.
That's what we have been arguing with here. Legal right, forget about his legal right. Is there a right to the governor? I mean, when I say governor, it is government.
But
He acts
governor has not exercised the power. There is another limb of my
on- No,
argument.
no, no, how can?
I'll come to Article 166.
The notification is
see.
the name of the.
Yes. No, it's not in the name of the government.
Yes.
Kindly see me, Lord, para
No,
5.
no. First things first.
Page 76. Page 76 and 7.
Of powers conferred Rule 30, Mizoram Health Services
Huh.
notified so and so, and in the interest of so and so,
Hmm.
as a
The
mandate.
governor is pleased.
Yes, governor is pleased.
Now, in the writ petition, my lord, there is an averment that the file was never referred to the governor. Anyway, my lord, first let us deal with this point.
Yes.
Please come to paragraph 5, my lord.
How are you affected?
My lord.
This is no public interest.
No, it's not a public. No, we'll be.
Therefore, in service jurisprudence,
Yes,
unless
I'm a person aggrieved.
how?
Because, my lord, we are aspiring to go to grade 1. And, my lord, he has been inducted into grade 1. Our promotional avenues would be
No, how is that possible?
jeopardized.
Your promotional avenue that has been taken care of
No,
by
no,
in situ promotion.
No, my lord.
In situ promotion,
Lord.
you get.
No, my lord, if there is a violation of Article 14 and 16, I did not plead prejudice. That's another point, my lord. In every case, I need not plead prejudice.
No, that's all right.
Yes.
That's all right. But then for you to invoke this jurisdiction,
Yes.
and if for you to say this, because you were the.
Well, I'll be directly affected because, my lord, my promotional avenues are concerned. I have a right to be considered for promotion, which is sought to be denied by the, if people are brought. Look, when the condition, well, deputation is not a
Anyway,
mode of recruitment.
Let's see the judgments that you are.
Yes, paragraph 5 and 6
Of
1976 4 SCC 543. But the argument of the state government and the corporation was, and this argument found favor with the division bench of the High Court, that until the cadre and recruitment regulations were amended, it was not competent to the corporation to absorb the appellant as permanent senior health inspector of on the establishment of corporation, and resolution of the corporation dated 30th December 1974, though sanctioned by the government by its order dated May 6, was not effective to bring about absorption of the appellant as permanent employee of the corporation with simultaneous termination of their services as government servant. The argument requires consideration of some of the relevant provisions of the cadre and recruitment regulation. The cadre and recruitment regulations were framed under section 6, 7, 84, 85, 88, and 94 of the same and were sanctioned by the state government under section 94G of the Act, and they came into force with effect from March 3, 1971, being the date on which they were published in the Government Gazette. Regulation 3 laid down the method of recruitment and minimum qualification for recruitment to various posts enumerated in the schedule. One of the posts enumerated in the schedule was the post of senior health inspector, and it was provided in column 2 of the schedule that method of recruitment to the post of senior health inspector shall be 50% by promotion and by 50% by deputation from the State Directorate of Health Service. Cadre and recruitment regulation does recognize only two modes of recruitment to the post of senior health inspector, namely promotion from the cadre of junior health inspector and deputation from the State Directorate of Health Service, and one half of the cadre was to be drawn from each of the two sources. No other mode of recruitment could be resorted to by the corporation under the cadre and recruitment regulation. It is difficult to see how, in the face of this provision, which has admittedly statutory effect, the post of senior health inspector could be filled by absorption of deputationists of senior health inspectors from the Karnataka State Civil Service. Senior health inspector from the State Directorate of Health Service could only be on deputation to the extent of one half of the number of posts of the senior health inspector on the corporation establishment, and they could not be absorbed as permanent senior health inspector under the corporation without violating the aforesaid statutory provision. This statutory provision does not contemplate any senior health inspector on the establishment of the corporation who are drawn from the State Directorate of Health Services, otherwise they are on deputation, and to absorb senior health inspector from the State Director of Health Services or permanent employee of the corporation would be plainly contrary to its express mandate. It was, however, contended on behalf of the appellants that when they were absorbed as permanent senior health inspector on the establishment of the corporation, they were already in the cadre of senior health inspector under the corporation, filling 50% of the post, and their absorption as permanent health inspector did not constitute fresh entry into the cadre, so as to require compliance with the cadre and recruitment regulation. The position according to the appellant was similar to that of the employee who is initially officiating in a post in a cadre and is subsequently confirmed in the post. This contention we do not think is well founded. It is only by way of deputation that senior health officer from inspector from the State Directorate of Health Service can find place in the cadre of senior health inspector on the establishment of the corporation. Not only their entry, but also their continuance in the cadre of senior health inspector on corporation establishment depends on their being on deputation. There is no scope under the cadre and recruitment regulation for their absorption as permanent senior health inspector under the corporation.
No, we have read it till
Yes.
paragraph 6.
Yes.
Now, an answer to this would be, Mr. Chaudhary, that this is with respect to recruitment regulations of Bangalore Municipal Corporation of
Correct.
1971. There is no reference of any relaxation clause there,
Yes.
right? So true it is, the proposition that you are projecting is correct.
Yes.
If there are two sources, one by recruitment, the other by deputation, it's all right. Here, it does not have even deputation. You have not questioned the deputation earlier. So deputation came, deputation with
No,
the.
even under this case, deputation was permissible.
No,
Here, 50% of deputation.
here it's all right. No, I'm talking about something
No,
else.
even here also there is rule 20, Milord.
Rule 20 deputation.
Yes.
All right,
It's there.
Then,
Please come to rule
where
20.
is the relaxation clause in 1971 Bangalore Act?
No, that's a different thing, my lord. What can be relaxed would be another thing. My first limb of argument is, my
Agreed.
lord,
The
as a deputationist, he
entry in
doesn't.
ser- Agreed. If entry in service is only through two modes, either
Yes.
deputation or direct recruitment,
Hmm.
there could not be any
Fair hard
absorption.
no.
Third mode, that's right. But only in case where the rules are absolutely silent about this power of the governor, aided and advised by the Council of Ministers or the body,
Hmm.
which is to take decision, the executive body,
Hmm.
if there is no power of relaxation of rule.
No, my lord, this not the judgment which I'll be referring now. It says, unless if there is no rule, there is the end of the matter. No question of absorption.
That
Yes, my lord. 2005 SCC 362. My lord, 2005 SCC 362, paragraph 6, at page 364. On the legal submission also made, there are no merits whatsoever. It is well settled that unless the claim of deputationist for permanent absorption in the department where he works on deputation is based upon any statutory rule, regulation, or order having the force of law, a deputationist cannot assert and succeed in any such claim for absorption. The basic principle underlying deputation itself is that person concerned can always and at any time be repatriated to his parent department to some his substantive position therein at the instance either of the department, and there is no vested right in such person to continue for long on deputation or get absorbed in the department to which he has gone on deputation. So, my lord, in my humble understanding, the law is absolutely clear. He has got no right. There's no question of invoking Rule 30.
So the context of educational qualification for a higher promotion.
Yes.
So therefore, that is not applicable here. Now, we are only on the issue of Rule 30
Hmm.
and its application.
Now, my lord, let me come to Rule 30 part. Now, my lord, Lordship
So
knows
so
this.
far as the proposition that you're advancing,
Hmm.
generally no difficulty.
Yes, no, my lord. I'm coming to the facts of the present case now. Now, Lordship knows there was a time, even Supreme Court, I mean, some of the judgments say that these are all cases of dim relaxation. As you would recollect, at one point of time, Supreme Court said that if there is a conscious decision over a period of time, despite there is a provision, government is acting contrary to it, it has to be construed as a case of dim relaxation. So, my lord, the position reached its peak, then Suraj Prakash Gupta came. Let us read one paragraph from that judgment, my lord. 2007 SCC 561. This is a judgment precisely on the power of relaxation. 2007 SCC 561. Now, if your lordship should kindly come to para 18 at page 577, the question which arose, para 18, page 577, the point number 1. Can the promotive for recruitment be
This
gets
is page 577.
my lord.
Yes, and which?
Para 18 was the bottom.
Yes, yes.
The basis of various submissions, the following points arise for consideration. Can promotees for recruitment to the gazetted service avoid the Public Service Commission? Can government order that the entire ad hoc stopgap service of assistant engineer and assistant executive engineer be counted for seniority? Can the order of regularization dated passed by the government be treated as amounting an implied relaxation of the rule of recruitment, requiring consultation with the Service Commission, whether relaxation of the recruitment rule is permissible? So, my lord, in its various facets, this is what, amongst others, failed for consideration. Now, my lord will kindly come to paragraph number 28. Now, under various heads, heads, my lord, the discussions were made. Now, at para 28, what lordships will notice is recent trend of cases. Recruitment rules cannot be relaxed. Decision of this court have recently been requiring strict conformity with the recruitment rules for both direct recruit and promotee. The view is that there can be no relaxation of the basic or fundamental rules of recruitment. In Keshav Joshi, the rule permitted relaxation of condition of service, and it was held by 3 judges bench. The rule did not permit relaxation of recruitment rule. The words may consult PSC, where it was observed to be read as shall consult PSC, and rule was treated as mandatory in so and so, so and so. So after referring to the my lord recent trend of the decisions, then if your lordships would kindly come to page 583, the summary.
Yes, para 31.
The result of the discussion, therefore, is that the wholesale regularization by order dated 2198 by way of implied relaxation of the recruitment rule to the gazetted category is invalid. It is also bad as it has been done without following the quota rule and without consulting the Public Service Commission. Now, this is important. Further, power under Rule 5 to relax the rule cannot, in our opinion, be treated as wide enough to include power to relax rules of recruitment. So eventually, my lord, what was said in Keshav Chandra Joshi's case, that what can be relaxed is a condition of service, not rules of recruitment, my lord. Now, authoritatively, Honorable Supreme Court held that rules of recruitment or eligibility criteria, my lord, that cannot be relaxed. So, my lord, to do favor to an individual, Rule 30 does not exist, my lord. Then the learned single judge, my lord, dealt with another case, that is 2013 2 SCC 516.
Sir, the photo portable sequence.
A perimetry provision, my lord, fell for consideration before the apex court.
Yes,
My lord will kindly come to page 539 on top, the relevant rule 33, which was under consideration, is quoted. Power of the governor to dispense with or relax any rule. Where the governor is satisfied that operation of any of these rules may cause undue hardship in any particular case, he may order to dispense with or relax the requirement of the rule to such an extent and subject to such condition as he may consider necessary for dealing with the case in a just and equitable manner, provided that the case of any person shall not be dealt with in any manner less favorable to him, and that provided by any of these rules. As has been observed by the learned single judge, which has been accepted by the division bench, there was no decision to relax the rules in favor of the special batch recruits. That apart, whenever there has to be relaxation about operation of any rule, regard has to be given to the test of causation of undue hardship in any particular case. That apart, the authority is required to record satisfaction while dispensing or relaxing the requirement of any rule to such an extent and subject to such a condition as he may consider necessary for dealing with the case in a just and equitable manner. Language of the rule really casts a number of conditions. It provides guidelines. It cannot be exercised in an arbitrary manner so as to dispense with the procedure of selection in the entirety in respect of a particular class, or it has to be strictly construed and there has to be apposite foundation for exercise of such a power. It is to be borne in mind that if a particular rule empowers the authority to throw all the rules overboard in all probability, it may not withstand the scrutiny of Article 14 of the Constitution. Be that as it may, no decision was taken, etc., etc. So, my lord, when the rule provides guideline, then, my lord, that guideline has to be applied and it must be evident from the order in what manner that guideline was exercised. Otherwise, my lord, it will assume the character of an action which is not protected by Article 14. This rule is not meant to, my lord,
This
overcome some individual
This paragraph has been quoted in the
in the
impeachment.
judgment. Yes. Now, if your lordship now kindly comes to page 76, the order is bereft of the basic essential details. Where is the satisfaction? Why it was relaxed? In the absence of reason, my lord, we are to understood that it was only to favor the respondent appellant. In exercise of the power conferred by Rule 30 of the Mizoram Health Service Rule, notified by dated so-and-so and published in the Mizoram Extraordinary Issue Number so-and-so, and in interest of public service, Governor of Mizoram is pleased to relax as amended for absorption of so-and-so, as a so-and-so, cadre of the welfare. That's all. There has to be some, my lord, the reasons indicated, my lord. There's absolutely nothing. So it has to be construed as an arbitrary exercise of power. Because the rule is very clear. Now, it is in this context, my lord, the observation of the learned single judge that no record has been produced assumes importance. Lordship knows in a certiorari proceeding, court will not go on requesting the respondent to produce the records. The moment rule is issued when a matter is taken up for hearing, my lord, it is the duty of the respondent to produce the record. Otherwise, adverse conclusion can always be drawn. Why in every case, my lord, government should be directed to show your bona fide, to show your, correctness of the decision-making process? It is your duty. The moment notice is issued, that these are the records we are producing before the honorable court for the, perusal. The records were not produced, record does not disclose. Why records were? If records were not produced, then adverse presumption would be drawn.
All right.
No, my lord, therefore, to sum up, my humble submission is very simple, my lord. Number one, reversion of a deputationist to his parent department, it does not involve any evil consequence. Therefore, Supreme Court has said long back, it does not attract the vice of Article 311. Number two, and deputationist has no right of absorption unless the rules of the borrowing department so provide. Number three, my lord, in spite of that, power under Article 162 can be invoked by the state in an appropriate case. But in those cases also, my lord, the power has to be exercised in the manner as envisaged in the rules. So here is a case, my lord. Is there any compliance of the requirement of Rule 30? There is none. Therefore, it has to be
Now,
constituted.
if you read the notification only,
Yes,
then perhaps you'll be justified.
yes.
But then notification by the government.
Then, my lord, then the noting in the file.
background facts it.
But the file was not produced as whose fault? It's government's fault. The government don't have the record. We all know, my lord, how things move in government. 20, 30 years back, things were different, my lord, when file movements were really good.
Who appears for government of Mizoram? What do you have to say? No. That's your decision.
Page 71.
Is 71.
Yes, have to. A letter written by the undersecretary of the Government of Mizoram Health and Family Welfare Department, the Director General ESI. Third paragraph, Government of Mizoram has carefully examined the application and found it reasonable enough to allow absorption of his into Health and Family Welfare Department, Government of Mizoram, given his good performance during his deputation tenure and his genuine family problems. Honorable Minister so has also given approval to the absorption of his
This was part of the writ record, no?
Yes, yes.
letter. In fact, Lordship, in Rule 30, Lordship, we have three conditions, Lordship, for relaxation. One is hardship in any particular case or in that exigency of public service as well as effective implementation. So effective implementation of that scheme. RTR.
Place of rule. Not scheme.
Lordship, family lordship, hardship, that is. And my case lordship, in my affidavit, we have stated our case lordship, page 92, paragraph 17. This is the affidavit of the government. Page 92,
Yes.
paragraph 17. With regard to the statement made in paragraph 19 of the writ petition, I say that 30 of Mizoram Health Service Rule 2009 empowered the governor of Mizoram to dispense with or relax or amend and repeal any rule if he is satisfied that operation of any of those rules cause undue hardship in any particular case or that in a
Which paragraph are you reading?
paragraph 17. Hardship in particular case or that in the exigency of public service as well as the effective implementation of the rule. That Rule 30 does not impose any requirement upon the governor to disclose the reason for relaxation of the rule. However, in the instant case, the notification for relaxation of rules specifically mentioned that the relaxation of rules for absorption of was in public interest and there are no extraneous consideration for absorption of the same officer.
The power is not so wide.
Yes, I understand.
The power is not so wide.
Yes, I understand.
This statement is not backed by the rules and the interpretation which should be appended to the orders. Nonetheless, we do not find that any extraneous consideration was there. And considering the fact that
Well, the private respondent, they have already got functional function in the year 2016.
that has been.
Actually, my only response is that, Lordship. It is not that I have come to this honorable court to enforce my right. The question which was raised by the other side is that I have no enforceable right. I have made a request, the government has exercised their power. My right has started from the impugn notifications of 24th August and 1st of September. Prior to that, I did not have a right for absorption. I made a request, they have acceded and they have analyzed the whole situation, whether there is a requirement or not. Therefore, my right has started not from the rules, it has from the administrative order. So that judgment of 2000 will not be applicable in my case, that I have no right for implementation or enforcement of that particular right for
Mr.
absorption.
Saikia, that may not be a ground, that may not be an answer. Since you are the beneficiary, the action of the government, that is under challenge.
But government,
You're not enforcing it, we understand.
Lordship,
This is the government's decision.
Next is-
Anyway, we are finding it, is a case which should be allowed. Where the appeal stands allowed,
deeply
the
obliged,
judgment should follow. later.
deeply obliged.
Lunch break. Lunch break.
Item 3,
Highly obliged.
Maybe. My lord, last occasion, direction was given.
Who appears for the writ petition? You're for the respondent, no?
I'm for the response.
Yes,
But my senior, she's appearing through VC.
yes, it's all right, we'll hear. Yes,
Actually, my lord, lordship may kindly come to my lord, last order, my lord, 13/5/2015 only.
13.5, yes.
Yes, my lord. Place on record the orders OM relied upon by the petitioner separately by supplying copy of the same to the learned counsel for the respondents in advance. But till date, my lord, They have not filed
If
any.
it's part of the record, let's find out, let's count for it from the records only. Yes,
My lords, my lords, I am basically relying on a OM of 10th February 2000, where what the OM says is that if someone's been absorbed in government service or in any organization from another department, then if their past service was on the same pay scale, they would be entitled to assured progression scheme and they would be entitled to promotion. But if they come from a lower pay scale and they are absorbed in a higher pay scale, then they would not be entitled to ACP. So that's the short issue. Now ESIC and this is a DOPT circular dated 10th February 2000, which is clarificatory of an earlier DOPT
let's see that,
circular.
let's see that DOPT memo, DOPT resolution.
Yes, my lord,
Memorandum of 2000.
my lord, 10th February 2000.
You were supposed to give a compilation of all the OMs and the queries made on that. See, the whole thing has been decided on the ground that the OM of 2000 stood set aside by a division bench, by a single judges, by CAT, which was approved by the division bench, and it was not interfered by the Supreme Court. That's one aspect of the matter. But here what had happened was that a large number of people were, were absorbed in a public sector.
By ESIC.
ESIC.
From governments.
So
So
therefore,
it
it was only an inquiry with respect to the fact whether they were absorbed on a higher pay scale. Now, if they
That's
were
right.
absorbed on a higher pay scale, the law is very clear that it would be taken as fresh recruitment and therefore no counting of back services. Agreed. So the CAT took an example of a case of a driver or somebody of a shorthand typist who had gone to another public sector organization from the High Court, and it was found that no, there was nothing there. So there the ACP rules were not in dispute. Now ACP and MACP rules have their own caveats, and those caveats have to be taken note of. Otherwise, it would be a double benefit and double jeopardy to the state. Double benefit to the person. Suppose, therefore, there was no question of your hurrying to the court. It was only an apprehension. Suppose you were given promotion, you were absorbed at a post which may be analogous but on a higher pay scale. Then it will be treated as not a fresh appointment. There can be no two opinions about it. You cannot come and say, forget about the OM of 2000. The queries and otherwise the rule of MACP, that's very, very clear. Every state has it for in situ promotion, financial upgradation. Now, therefore, tell us what do you have to argue on that? That inquiry has to be made with respect to each of them, whether they were.
My lord, very simply, what happened in our case was, and some of the circulars are there in the review. They are perhaps not so clear in the writ, which is why perhaps the court had told us. If your lordship will see my writ petition, para 9 and 10, and para 17 and 18 make the position very clear. Perhaps 18, if your lordship will see, your lordship, the position's very clear of the writ petition, that as per the letterhead, letter dated 19, para 18 of the writ.
Writ record.
The review was allowed by your lordship, so now the writ has to be heard.
This is affidavit in opposition. Paragraph 18 is at page 10. Page
Yes.
Para 18. That as per the letter dated 19/25/10/12, the private respondents were allowed higher pay scale at the time of absorption in ESIC on 1/1/2006. Their pay scale in the state government was 3490 to 8100, and in ESIC.
This is against your case, no? Why are you reading that paragraph?
No, because they are, it's not,
Case of ESIC is based on this only, no?
yes. So 4,500
Whom are you arguing for?
ESIC.
Why you are arguing for ESIC? Oh, that's right, that's right. All right. I thought you were for the private.
Right.
All right,
No,
we have
no.
followed that.
Well, also, what I am
We have
saying
followed
is,
that, Ms. Luthra, we have followed that. Now, let us hear them.
In fact,
We
my
have
lord,
followed- we have followed your argument. They would be fresh, that would be treated as fresh appointment, and therefore the past services cannot be counted. Especially, and not for all, but for those who were appointed even though on an analogous post, who were absorbed on an analogous post, but with a higher pay scale. And this could be discerned only with respect to two of the employees, and therefore an inquiry was made. When it was already at the incipient stage, writ petition was filed, order was passed, which order stands reviewed. Therefore, the writ petition is to be heard again, right? All right, your case is made out, yes.
my lord, now lordship may kindly come to page 146, my lord. It is their own letter, my lord. The letter was written to the medical commissioner,
146.
146, by the medical superintendent. Page 1.
Yes.
My lord, I'm reading, my lord. In reference to the subject cited above, I would like to inform you that Sri Nolini Kumar
One
Adhikari,
second. Let me come to that page, yes.
146. In reference to the subject cited above, my lord, I would like to inform you that Sri Nolini Kumar Adhikari of ESIC Model Hospital, Beltola, Assam was serving as pharmacist since joining an ESIC scheme Assam in the pay scale of rupees 3490 to 8,100. On deposition to ESIC, his pay was fixed in the pay scale of rupees 4,500 to 7,000, which is the lowest pay scale of pharmacist cadre in ESIC. Therefore, it is assumed that the pay scales granted as mentioned above was corresponding equivalent to the pay scales of pharmacists in the ESIC state government at not in a higher pay scales. This is important, madam. Not in a higher pay scale of pharmacist cadre in ESIC. Therefore, it is assumed that the pay scales granted at mentioned.
That's all right. So therefore, if it is the same, then perhaps nothing shall be recovered from you. That's with a special case. You know, the writ petition was filed before any decision was taken. So that exercise has to be undertaken. No, otherwise you stand to get unduly enriched on the government money, which is the money of the public. So that is true. With respect to you, we are not passing any order for recovery. We only say that what was done by the ESIC was to have an inquiry with respect to all these absorptions, and then see whether the payment of whether the ACP or MSCP was correctly paid. So why to obstruct that?
Well, they have taken, first of all, my lord, they have taken the shelter of the OM data 10 to 2012.
They have not taken.
That was
shelter.
set
is what
aside
the-
way back in the
that
year
is what the
2011.
says. That is what the tribunal says. They have not taken shelter of that. If it would not have been allowed, the writ petition would not have been allowed in the first instance, perhaps the process would have begun.
And in
So
fact,
he will ensure that an inquiry is made if your initial absorption was on a higher scale, you were not entitled for ACP. And if you have been paid, that will have to be recovered or adjusted.
my lord, I just want to show page 98. it may also be clarificatory, but the fact is this, that those, I mean, the principle is that OM which my learned friend is referring to, several division benches of various high courts of the country have interpreted that OM to be exactly the way your lordship has said, that if they had not been absorbed at a higher pay scale, then they will not get the benefit of past service. If they are absorbed at the same pay scale, they will get the benefit of past service. So that OM, which has been explained, in fact, has been upheld by 6-7 division benches of the Delhi High Court in 2 cases. All those I had given as a compilation to your lordships in the review, as well as otherwise those judgments. But
Very
may I
glad-
just show page 93? I just open that review. My lord, just see page 87, 2015.
Page 98.
It's written as 93, annexure 8. My lord, the page numbering is slightly odd. So I have to inform the court that we have started paying.
For the satisfaction of the council appearing for the respondents, you please follow the order dated 13/5/2025. You are yourself prayed for it. Place on record the orders OMs relied upon by the petitioners separately by supplying copy of the same to the council for the respondents in advance. Make a
Yes.
compilation, let it be given to him. Otherwise, prima facie, you have made out a case. Give it to him
Grateful, my lord.
and 2 copies to us. We keep it on the next hearing day.
Very well. Can I then request a day when I can come physically if possible?
Why not? Whichever day is
4th September, convenient.
Which September? Which September?
4th,
4th September can be kept. It's a hearing day.
4th,
All right, 4th September. Okay.
very grateful.
By order dated 13/5/2025, the counsel for the petitioner had made a request to allow time for placing on record the orders/OMs relied upon by them by the ESIC separately by supplying a copy of the same to the learned counsel for the respondents in advance. Stop. It appears the same has not been done so far. Stop. Let the same be done in 2 days. List this matter for hearing on 4th of September. Yes,
Grateful.
sir.
Item 4 to 6.
Yeah.
May it please your lordship.
Yes.
I have an extraordinary prayer, my lord. The additional agent, PN Goswami, my lord, he's conducting the matter on behalf of the state, my lord. He had some urgency, some difficulty last evening.
That's all right. We have no difficulty. You should have told Mr. Chaudhary, no?
My lord.
He should not have waited for so long.
Arguments can proceed, my lord. We, for the state, my lord.
That would not be appropriate. When do you want it?
Any day, my lord. Next week.
At the request of the land council for the respondent, the matter is adjourned to. Your date?
21/8.
What is the matter about?
This is, Lalit Single Judge has referred this matter.
All right, what is the issue?
The issue is, my lord, a junior engineer, while they're in service, if they acquire the BTech or BE degree, then they're promoted, Milord. And that is to be treated as a direct recruitment. Now, the issue is in this case, Milord, we have acquired after we applied for the post and before appointments were made. The learned single judge has interpreted by the rule.
But this is writ petition, no?
Yes.
That's been referred, yes.
A coordinate bench of this honorable court has said that no, it is not required. But the honorable single judge who has referred the matter to the DB Milord was of the view that one must acquire the qualification before entering into.
No, that law is not there. That is settled law. I think it's something else, no?
No, that is the point, Milord.
Is that the point?
Yes. In fact, my lord.
I don't know, the point appears to me to be
Ah.
that, instead of giving you promotion and taking it as fresh recruitment on the post of assistant engineer,
Yes.
the government has come out with a notification asking for fresh.
No, what the government did, Milord, when government came up with the advertisement, then since we are eligible to be considered under that particular rule, we made a prayer. When our prayer was not considered, then we approached the honorable single judge. And we also cited the other judgment.
I thought that you are preventing the state.
No,
You're
no,
against
no.
the state
No,
from
no.
coming out with that.
No,
advertisement.
because we have a claim, that's why 37 post has been earmarked.
Okay. उसमें क्या बहस करो? I don't think there is any issue. Let him come.
No, it's okay. Well, like,
That cannot be. Just that it's a fresh, if you have acquired the degree, because that was the terms of your appointment
Milord, the
earlier.
idea is to fast track the promotion, those who has got degree. Now, whether before or
Why
after,
is the state opposing it? I don't know.
state advertise the post for direct
There's some
recruitment.
therefore that. I perhaps got the impression that you.
No,
don't
we are
want
not.
Others,
no,
you
we-
want your.
Within our quota,
within
Milord,
your
yes.
quota.
We are not
That's-
stopping the direct recruitment per se.
That's a decided concept. There's no difficulty. Why would the government go against it?
Yes.
You have a experienced hand in that quota. Who appears for the state?
Mr. Goswami Milord.
PN Goswami, additional.
Today he maybe had some difficulty. That's all.
And I think it's only you who has to argue. Mr. Chaudhary has finished his argument. On that day, you just let us know.
Milord, 21st, I have some difficulty. Let it be 4th of September, Milord.
Again, 4th of
Fourth,
September,
fourth,
4th of September. On 4th of September, I'm informed that there are many matters fixed.
Okay.
After that,
22nd, it can be done, Milord.
22nd of
Friday.
August.
Huh.
Oh, yes, 22nd.
Possible?
Friday, huh? 37 posts have been kept
Yes.
reserved.
Item 7.
Please, your lordship. In fact, if I argue this matter, this will be only on academic interest. Nothing is survived. But the issue, how a president of a Jilla Parishad.
Let us not get
Yeah,
into any academic question.
Yes, that issue may be kept open, lordship, with that observation,
Which
lordship.
issue?
The issue is that whether
With respect to resignations.
resignation, whether the withdrawal of the resignation should be directly given to the government or through the deputy commissioner.
No, that will depend upon the Panchayat Raj Act.
Exactly, lordship.
So where is that Panchayat Raj Act? Tell us. Whatever it is.
Yes,
I go by the act which I am
yes.
familiar with.
Assam Panchayat Act
Panchayat.
1994, section 72. Resignation of what to put aside.
No,
Yes,
not this.
72.
If it is the same compilation, page seven.
Yes.
Section 72.
A member holding the office of the president of the Jilla Parishad may resign his office at any time by writing and send it to the government through the deputy commissioner. This is permissible. And the vice president of the Jilla Parishad resign his office at any time by writing and send it to the president of the Jilla Parishad and in absence of the president to the government through the deputy commissioner. And the office shall become vacant on the expiry of 15 days from the date of such resignation, unless within the said period of 15 days, he withdraws such resignation by writing and send it to the government. This is the core issue.
That's right. So sending it to the government.
Yes, in
The-
respect of the president
Just-
and
The letter of resignation has to be sent through the deputy commissioner.
not to the government
Deputy commissioner through the
Yes.
government.
For
But
the
with
withdrawal-
Withdrawal, it is only the government.
directly.
That's all right. So where is the difficulty?
That reversely decided by the learned single judge.
No, no. The learned single judge, has he decided like that? I don't think so. He says the same thing. He refers to it. After dealing with the law of resignations, he deals with it. And he says that there is a distinction. Sending resignation there is a different process, which is also unilateral. Withdrawal also is unilateral. And there the distinction, it can directly be sent to the government. And the issue has been decided.
The facts here was that his withdrawal was also given to the deputy commissioner in WhatsApp, which was forwarded to the government.
No.
The
Yes,
factual
the-
difference.
The court.
So let it be closed, Lordship. This
the
issue
court-
will,
Just a minute, just a minute. The court took the view.
Lord.
See, the objection could be of the other side, whether a WhatsApp message or any communication by email
Yes.
would be considered to be the communication to the government.
Even the addressing of the withdrawal letter, to whom he has addressed.
Not necessarily if it reaches the
Suppose it
government.
is addressed to the deputy commissioner, he is not the appropriate authority to receive that withdrawal communication.
Let it, this question, we close this petition.
Yes, Lordship.
Without
Yes.
deciding anything.
Yes, Lordship.
The matter is, because he must have
Yeah, under that factual, the situation is over.
under no confidence.
Ultimately, we got a stay order and he continued and he completed his term. I am for the government, but the private respondent, he also challenged the respondent in that case. So he got his relief. We kept this
Term is over.
term is over about a year back. And fresh election had also taken place. New incumbents are in the place.
Take it.
I do not want to waste this honorable court's time. That's
The law of
usually futile.
resignations- The law of resignations. is also the matter of-
Assam Panchayat Ka 19
No, T.P. Chaudhary has written a good book on law of resignations. And this has been, the judge has taken note of it. The respondent, Ashish Nath, was declared elected as a member of Karimganj Jilla Parishad and was also elected the president of the said Parishad. While efforts were on for moving a no confidence motion against him, he resigned from the post on 18/9/2021, which letter of resignation was sent to the district commissioner to be communicated to the government. So, before the expiry of 15 days, the claim of the respondent is that he withdrew his resignation. A contention was raised that such withdrawal of resignation was beyond the prescribed period of 15 days. The learned single judge, while dealing with the case, found that it was within time. While saying so, the learned single judge dealt with the law of resignations and also the facts of the case, holding that the resignation was withdrawn by sending a WhatsApp message as also the email to the government. So some objections were raised with respect to the admissibility of such electronic messages, bracket WhatsApp and email. But the major concern of the state, major concern of the respondent in the writ petition was that even that was that the letter of withdrawal of resignation was not addressed to the government, but to the deputy commissioner, which was not in consonance with the provisions contained in section 72(1) of the Assam Panchayat Act. However, with the passage of time, this appeal has become infructuous for the reason that the term of the respondent expired, and thereafter new election also, and thereafter new elections were held, fresh elections were held, and the panchayat body has, and the fresh panchayat body appears to have taken, the first appears to have been convened. In that view of the matter, we do not find any necessity of continuing with this appeal. We thus close the same as the appeal having become infructuous.
Issue may be kept open though.
Needless to say that the issue with respect to the validity of the issue raised in this appeal,
Mode of withdrawal.
namely the mode of withdrawal of the resignation of a member of the panchayat of the Jila Parishad, would remain open for any future deliberation.
Deeply obliged.
Item number 8.
Maybe, Your Lordship. Before
Yes.
my learned friend starts, I want to point out one thing. I filed on my affidavit in opposition, and my learned friend filed a reply to that petition, but one page in that affidavit is missing, Lordship. In the court
One
record also it is, yes, Lordship. In the
Look
court
that
record.
page.
Court record. No, it is in the court record also, it is
In
missing.
the court record.
Lordship, I mean, we are allowed to correct it, Lordship.
File it. File it by an affidavit,
File it, yes, sir. Lordship.
as prayed for on behalf of the appellant, re-notify on given dates. You file it,
Lordship. Only that particular page, Lordship.
Yes.
Or I'll
only
refile.
that page, but with an affidavit that it is the correct page.
Lordship. All right.
We are
9, 7.
saying this because we should not have permitted you to do so, but since objection has been raised, we only say that you take time, we have permitted you.
Lordship.
Do it.
9th of September. Item 13 and 14.
In this case, Lordship, the facts of the case is not very important. The importance is that there are two contra views of various learned single judges on the issue of revoking of suspension or setting aside of suspension
Yes.
by relying on Ajay Chaudhury's case, Lordship. So I'm praying for a short date, Lordship, where I can make a proper submission.
So, but that will depend upon the wordings of the service rules.
Absolutely, Lordship. That is number one. And
We
number
will not go beyond.
paragraph 21 and 22 of Ajay,
Normal service rules say
Lordship.
that within 3 months, or
Lordship.
whichever is the period, 3 months,
Lordship.
charge sheet should be, charge memo should be filed.
Lordship.
If charges are not filed within that period, before the expiry of that period, the department can extend that period of suspension by giving reasons,
And by a review meeting,
by another 4 months.
Lordship,
Thereafter, the suspension has to be revoked.
Lordship.
That's the law.
Yes.
Only
That's
problem
not-
in this case is, my lord, there is no stay order. I was asked to be reinstated. I have not been reinstated till that. Substantial time has expired, my lord, in the meanwhile.
Mr. Saikia,
Then I can start the argument with it,
View is,
Lordship.
do it properly.
Mm.
We will not force you to make an
No,
argument
no.
today. Our view is that, let him be posted to any other place
Exactly.
and give him his salary that
In fact, Lordship,
expedite the departmental.
in fact, this honorable,
Punish him, throw him out.
the situation is very grave in this case. A magistrate converted a murder case into a suicide case, and all the other persons, the SP and all, they're all dismissed.
It's a grave misconduct.
Very grave.
He should be shown the door.
No, it
Make
is
him
almost,
exit the service, but then why keep it pending?
it's a very, in fact, Lordship, all the other time, I am not taking time. In fact,
No, Mr. Saike, please, we are granting you.
Lordship.
We are granting,
So a short date may be given, Lordship, it will take some time.
as prayed for on behalf. Let us see the rules on that day, not
Lord-
today. We will
Lordship.
just see the rules and.
Lordship.
There is no
Because
flexibility.
what I am trying to emphasize in this case, Lordship, that we can, almost the DP is at the final stage, we can immediately dismiss him also. That is not an issue. That is individual case, but
No,
the,
finish it. This will be over.
that is what I,
Take your time, but Mr. Chaudhary would like it to be argued first, reinstatement, but what will you do with that?
My lord, if I am guilty, hang me. I'm not on that. But don't keep me hanging.
That in fact should be the approach,
Lordship.
so that you take word from him, and then if finally you decide.
My lord, I am a revenue service officer. I am being made, without imparting any training, I am being made to discharge the role of a circle officer and to do inquest. Did government ever imparted me what is inquest, how to do an inquest? I am not a civil service officer.
You should have denied that.
No, my lord. There was,
should have
no,
denied
there-
that.
my lord, and there was some, I mean, aberration on my part, but
Merits we'll see
Yeah.
sometimes else.
no, bad facts also can make a good law. It's not necessary that bad facts will always make a good law, my lord.
Mr. Chaudhary, you will agree with me, in 60s and 70s, only very gross facts
Precisely.
paved way for good judgments.
That is why it is said, my lord, we are concerned with the decision-making process. We do not.
Now, what is the stage of departmental proceeding?
Only the decision is pending.
Oh, then by that time conclude it.
Lordship. In fact, the other persons, the SP and other
In fact,
officers, they are already left the service.
in fact, give opportunity to Mr. Chaudhary to file an appeal.
My lord, the doctors who perform the autopsy, they have been reinstated. I can only tell that much.
It is one of the very classic case of Assam.
The doctors, they have been reinstated.
And which officer has been dismissed?
SP of police, very senior police officer. He along with this and they 3-4 persons conspired a minor girl.
And what happened? What happened in the criminal case?
Criminal case, the trial is going on. A small girl, a housemaid, she was shown to committed suicide. Otherwise, she was killed after raping. A very serious case. These
child
cases
against-
open the
not
conscience
all,
of the
child
people of
against me is
our society.
No. So
Very serious case, Lordship, this.
that's right, Mr. Saik. Yeah, but-
That's why the SP and they have already been dismissed from service.
Only the judgment has to be written by
This
the
is-
disciplinary authority.
Yes. These are written instructions I have received, Lordship.
4 weeks.
Let it be 2 weeks.
You want a hurried judgment
Not a
in
hurried
the
judgment, my lord.
departmental proceeding, not here.
My lord, I am also, my lord, waiting and waiting and waiting what to do, my lord. Matter is listed.
It would be very short-lived, no? All that you know is it will be very shortly. So we keep it after 4 weeks, we'll hear. We will, unless you have real reservation in
No, not real reservation, but I want an early disposal. That's
3 weeks. That's 2 weeks, we are bit tied up.
It's okay.
3rd week.
Go ahead.
11/9.
11/9.
My lord, if I may interject, item number 14, my lord, slightly different, slightly separate on fact.
I mean, hear it on the same day.
Yes.
9.
You'll hear it on the same day.
Yes, ma'am.
Deeply obliged, Lordship.
11/9. 11/9.
Yes.
Item 15.
Yes.
May it please your lordships. My lord, the writ petition was filed by the appellants
Yes.
challenging the promotion of the private respondent to the post of junior information officer. And my lord, the primary ground of challenge was that the promotion was made.
I got distracted for a minute. I was looking for your name. You're Mr. Chaudhary.
M.K. Chaudhary. my lord.
All right. You begin afresh. Yes.
Now, the promotion of the private respondent was challenged on the ground that, my lord, the feeder post for the, my lord, under the rules, the feeder post for promotion to the post of junior information officer is librarian, and the private respondent was, my lord, translator. So, my lord, under the rules, there was no avenue of promotion from, my lord, the post of translator to the post of junior information officer. It is only, my lord, the librarian and some other posts.
Let's see the rules.
Yes, my lord. The rules. Relevant provisions of the rules, my lord, rules have been annexed on extra copies. Extra copies.
Page 9, page 136. Page 9.
Now, your lordship may kindly.
Crime Information and Public Relations Service rules.
My lord.
Is that the rules that you're talking about?
Yes, my lord.
1986. Yes, let us come to the
Promotion.
relevant provision.
Promotion is at, my lord, page 9, rule 11.
Yes.
Vacancies in the cadre of additional director so-and-so in class 1, information officer, in class 2 service to the extent of specified in rule 1 and 2 shall be filled up by promotion, then 2.
Just the
subject to-
vacancies in cadres of additional director, joint director, deputy director in
Yes,
class
my lord.
1. And information of, this is promotion to which post? In
My
the-
lord, this is promotion that is, my lord, that your lordship will find at the 2 Roman 5. This is the promotion for the post of junior information officer in the class 3.
Journalist.
Journalist, sub-editor come proofreader and librarian to the junior information officer. And the private respondent was a translator. And my lord, this has not been, translator has not been included in this, my lord. figure.
That's right. Let's see the other provisions.
My lord. Other provisions, your lordship will may come, my lord. Rule 3 may be relevant, my lord. There are 3 cadres, 3 classes, my lord.
Rule 3.
Rule 3, my lord.
Class cadres. and
Class 1, class 2, and class 3. Class 3 is, my lord, it shall consist of the cadre of junior information officer, which shall includes the assistant editor, publication assistant publicity officer, press research officer, managing manager of print, script writer, publication assistant, subdivision, and public relation officer. So these are, my lord, class 3. Then one rule, my lord, which has been relied by the honorable single judge while rejecting my petition, that is, my lord, sub rule 2. The service may also include any post equivalent to a post in any of the cadres mentioned in sub rule 1, and any cadre or post laid down by the government to be included in a cadre of service.
No, what is sub rule 1? Any post equivalent to a post in any of the cadres mentioned in sub rule 1. Sub rule 1 is this. Where is that rule?
Sub rule 1 of what?
Sub rule 1 of what?
Sub rule 1, my lord, in 3.1.
Then dismiss.
Three-
Sub rule 3.1.
Sub rule 3.
Now, my lord,
The service shall consist of following classes. and
This is sub rule 3, 3. Equivalent to a post.
I don't understand this. Any cadre or post laid down by government to be included in a cadre of service.
then your worship may kindly come to sub rule 1 D. D is, my lord, it shall consist of the cadre of junior information officer. So class 3 consists of junior official, my lord, information officer, and my lord, the petitioner was aspiring for that post, where my lord, the private respondent has been promoted. So, my lord, junior information officer is a class 3 post. And my lord, the provision that was relied by honorable single judge is, my lord, sub rule 2, which says that, my lord, any cadre or post laid down by the government to be included in the cadre of the service. Now, my lord, this sub rule 3 to B cannot be read in isolation. It has to be read with rule 3.1, my lord, because rule 3.1 says where, my lord, these posts can be included in this cadre. Now, if your lordship has already read the, my lord, promotion rule 11. Rule 11 confines promotion to the post of junior information officer from the feeder post of journalist, sub-editor, proofreader, and librarian, which the petitioner is, appellant is, and, my lord, the translator is not included. Now, your lordship may like to read the, my lord, the findings of the honorable single judge. Where, my lord, the honorable single judge has erred.
Yes.
The honorable single judge has.
Where is the provision of a translator? Which cadre would translator be in?
My lord,
Mr. Chaudhary, you're appearing for the.
Yes, yes. My lord, will kindly come to page 145
Of?
of the paper book, my lord.
145.
Yes.
Yes.
Now, Roman 5, my lord.
But what is this?
Yes.
Which document
From,
is this?
this is part of the rules.
This is part of the rule.
Yes. From journalist, sub-editor come proofreader and librarian to junior information officer. Now, their case is, my lord, translator is not included here. Therefore, we are not in the feeder cadre.
Yes.
That is their case.
That's right.
Now, my lord, our case is, my lord, this will also include such posts as are included. Government has already said, we are getting the same pay scale.
Where is that?
Yes, when we were recruited, my lord, in the year.
No, but has the government come up with any notification?
Yes, yes.
no much.
Huh?
Yes, yes,
That
it
is
is.
where the catch lies, but there is no
No,
notification.
no, it is there.
Just show that.
Yes, yes. My lord will kindly come to the first selection advertisement to the home. Please come to my lord, page number 59. This was the advertisement, my lord, pursuant to which the appellant, we all were recruited. Kindly see, my lord, on the left-hand side.
This illegible. Absolutely illegible.
Okay, this is.
My lord, there is a better copy of the advertisement at page 253. My lord.
Okay.
253.
253, yes.
Yes.
Now kindly see, my lord, translator 5 posts, journalist 1, sub-editor come proofreader 1, proofreader, etc., etc. So when the recruitment was made, pursuant to which we entered the service, this was pursuant to this advertisement. Therefore, it was grouped in the same, my lord, group, or rather cadre. Then my lord will kindly come to page number 61. That's the appointment order, pursuant to that advertisement.
Page number?
61.
Yes.
Serial number 2, my lord. Let me read it. In persons of the notice that is so and so and subject to discharge without notice and so, the following candidates are selected on merit basis. So I am at serial number 2, my lord, Moushami Bhattacharya. Respondent number 7. Then if a lordship will kindly come to the next page, page 62. Kindly see, I was appointed as a translator. And the appellant is at serial number 11, Nilam Saikian. She was appointed as a librarian.
So pay band, grade pay.
Same.
Everything
Same.
But
Then, my lord,
that would not make it the feeder panel unless the government decides to allocate.
no, if your lordship kindly comes to that rule once again, page 139.
Yes.
Page 139. This service may also include any post equivalent to a post in any cadre mentioned in so and so, or any cadre or post laid down by the government.
This is while talking about class 3.
Yes. Well, that is, my lord, actually, my lord, every service rule in the state of Assam frame under
Service
proviso to Article 309, my lord.
Equivalent to a post in any of the cadres mentioned in sub rule 1.
My lord, my lord, the spirit of the rules are like this. When the rules are notified, the cadre strength is indicated. Subsequently, my lord, by notification, they keep on adding. And we get the same pay scale, same.
But there is no specific memorandum of
There is,
government.
there is none. Let us be fair. But from the conduct of the government and understanding of the government also.
You have been able to show that.
Yes.
It falls in the same bracket.
Now, if just 2 documents, then my learned friend can resume, my lord. Then, my lord, at page number 169, is the gradation list. Page 169.
It is illustrative. It is not exhaustive.
Page.
Yes,
Yes, yes.
which other document were?
Yes, my lord, the gradation list, my lord, at page 169.
169.
Yes. The provisional gradation list of translator, librarian, journalist, Bodo translator, missing, etc., etc. I am at serial number 7 and my learned friend's client is at serial number 13. So the common seniority. Then next page, my lord, 170, another gradation list, same position.
That's all right.
Yes. And there's one vital document, my lord. Yes. Huh? Please come to 167, my lord. Perhaps that will cleanse the issue.
167, yes.
Yes, it's a communication from the director to the government, my lord. Please come to the last para. And kindly see, subject is encadrement of translator. The subject.
Yes.
Rule 11 to 5 of the Assam Information and Public Relations Service Rule 86 has clubbed together journalist, sub-editor, proofreader and librarian together for promotion to the junior information officer group. The scale of pay of translator is also equivalent to that of this post. As such, their appointment will
alright,
be
this is-
guided by the same rules, no separate service.
So increment is there.
No, my lord, it's not there. I'll come to that, my lord. Before that, my lord, my learned friend has brought to your lordship's notice the advertisement. Your lordship will come to that page again, my lord, 253, because, my lord, the requirement for the post of librarian is different from that of the translator. Take page 253, serial number 2. Now, your lordship, may I read, my lord, serial number 2, the required qualification.
253.
This part is common for all these posts. Translators, my lord, journalist, sub-editor, and my lord, proofreader, etc., librarian. Educational qualification, the minimum educational qualification is a bachelor's degree in arts, science and commerce from any recognized university with a minimum 6 months diploma in computer application with typing and skill in Assamese. Other essential qualifications, a candidate must be capable of translating any matter from Assamese to English and vice versa in chaste language and must have good exam command over English language. Then, my lord, librarian. For librarian, my lord, they give specifically some qualification. Educational qualification, the minimum educational qualification is bachelor's degree in library science or graduate in any discipline with PG diploma in library science.
The educational qualification could be different.
Different.
For it to be in the same bracket, in the same, I mean, if it is in catered, then it falls part of the feeding cadre, no?
Yes, my lord.
Qualification may be different.
Now, my lord, the document my learned friend has been relying at 167 is not a notification, my lord, uncovering the post of translator in that, my lord, that in the feeder post. This is only a communication, my lord. This is a communication from the director who has all along been helping the respondent number 7, my lord. This is only a communication to the effect that, my lord, this may be included in the service rules. There is no gubernatorial notification or notification from the government stating that, my lord, these posts of translation.
Such a requirement also.
My lord,
There is no such requirement also. Look at this, look at the rules. Now, if you come to page 4, class 3, the service may also include any post equivalent to a post in any of the cadres. Any cadre or post laid down by government to be included in a cadre of service.
government, my lord. The government is the word, my lord. This is not a, my lord, communication of the government. This is a communication of the director to the government that which may be included. That
This
has
may
not
be
been-
included, yes. And then what happened?
that has not been included, my lord. In fact, my lord, in the affidavit, your lordship will find of the government.
Proposal suggesting to government to empower the select translators.
So this is only a proposal from the director that it should be included. But, my lord, there is no notification. In fact, my lord, in the affidavit of the government, it has been clearly stated, my lord, the affidavit, your lordship will find at page 115. It starts at my lord 111. The relevant paragraph I'll read, my lord. Paragraph 6 is the relevant part. Page 115, your lordship will read, my lord. 1, 2, 3, 4, 5th line. The notifications or orders facilitating promotion of translator to junior information officer must have been issued on the basis of some office record issued by the Home Department. However, no such notification or order could be traced out in our directorate department as in the year 1997. The Information Public Relations Department was created as a separate department. So, my lord, that document is not there. Then the, my lord, Honorable Single Judge, my lord, wanted to know, my lord, what is the status? My lord, an order was passed. An order was passed on, my lord, 22nd of October 2024, my lord.
Okay.
My lord, the Honorable Single Judge wanted instructions on this, my lord, that you could not locate. Now, this is the, my lord, what is recorded in the order. Heard Mr. So-and-so, so-and-so, so-and-so. In terms of the last order dated 26/9/2024, Mr. C.K.S. Borua, Learned State Council, has produced the instruction dated 5/10/2024 to the effect that no notification as regards selecting translator could be traced out in the Director of Information and Public Relations Dispute. So, my lord, the only document that has been relied on by the, my lord, the respondent number 7, as well as the, my lord, accepted by the Honorable Single Judge, is the communication from the director that it should be included. So, my lord, the law is very clear. And one more statement, my lord.
Has it been dealt with by the?
My lord, one more statement, if your lordship kindly bear with me, my lord, page 116. Government's affidavit again, my lord. It starts at the last sentence, 115. The apprehension of the petitioner that more translators and persons from other posts will be promoted to the post of junior information officer is not based on facts, as the department promotion committee meeting held on so-and-so has kept the process of promotion on hold. The process of amendment of services comes to its logical conclusion. So, my lord, they have proposed an amendment incorporating that, my lord, the translator in the feeder post. That, my lord, amendment is still to come. Therefore, I'll be guided by the rules which is in existence, the extant rules. Now, the Honorable Single Judge, my lord, accepted this communication and another communication from the director to the government said that, my lord, the translator post should be included. These are the two documents, my lord, on which the Honorable Single Judge relied as if, my lord, it was a, my lord, decision of the government. It is not a decision of the government. Your lordship will kindly come to the impugned judgment. The issue has been framed, my lord, that your lordship will find at paragraph 24/303, page 303, that is the issue frame.
Paragraph?
Paragraph, my lord, 24.
24.
25. 303. The issue that arises for consideration, my lord, page 303, my lord. The issue that arises for consideration is whether promotion from the post of translator can be made to the post of junior information officer under the 1986 rules when the rules does not provide translator as a feeder post for promotion to the said post of junior information officer. This was the issue framed, and my lord, findings thereafter, my lord, from paragraph 25 onwards. It is apparent that in terms of rule 11(2), an officer holding the post of journalist, sub-editor, proofreader, and librarian are only eligible for promotion to the post of junior information officer. However, it appears that under Rule 3(2), the services may also include any post equivalent to a post in any of the cadres mentioned in Sub-Rule 1, and any cadre or post laid down by the government to be included in a cadre laid down by the government. Thus, apparent in addition to the cadre prescribed under 1986 rules, the state government may either include any post equivalent to a post in any of the cadres mentioned in Sub-Rule 1, and any cadre or post laid down by the government to be included in the cadre of service. Thus, under 1986 rules, the government has the power to either take any post equivalent to a post in any of the cadres mentioned in Sub-Rule 1 of Rule 3 and take any cadre of post to be included in the cadre of service, though such cadre of post is not included in Rule 3.1 of the rules. Then, my lord, paragraph 26, it states, my lord, as such, in addition to the listed feeder posts anchored under 1986 rules, any cadre of post may also be included by the state government. Thus, under the 1986 rules, promotion from one cadre to another cadre need not be restricted from the feeder post anchored therein, and the state government has the power to include any other post, either equivalent or as laid down by the state government. Now, my lord, the question is whether it has been included. Now, my lord, to hold that it has been included, my lord, these two communications have been relied on in paragraph 28. First is, my lord, 16/8/1994 regarding encadrement. This is a, my lord, communication from the director to the deputy secretary. And, my lord, it says, my lord, in paragraph in the next page, in inviting a reference to the later on the subject quoted above, I have the honor to state that the post of translator of the directorate will be created and permanently retained by the government. As such, the proposed encadrement of the translator may perhaps be made by the government. So, my lord, the director was urging the government to, my lord, include that post. Similar is the communication, my lord, at paragraph 30. That is also a communication from the director to the deputy secretary. So, my lord, on the basis of these two, my lord, documents, communications from the director, the honorable single judge, my lord, in paragraph 31 has held that it has been encadered, which is wrong, my lord, apparently. May I read paragraph 31, my lord?
Now there's come to the rules that you have provided to us at page 4.
My lord.
After D, class 3, the service may also include any post equivalent to a post in any of the cadres mentioned in sub rule 1. And any cadre or post laid down by government to be included in a cadre of service.
Yes, my lord.
So this request for encadrement is something else.
Yes.
Now it comes under 2A, as you would find from the second communication which has been quoted by the learned single judge.
Page 226.
Come to page, internal page, I mean before paragraph 31, that communication.
Yes. The nature of job.
It lays down the procedural requirements. My lord, it speaks of the procedural requirements in the para B.
Right. So now let's see, rule 11.25 D of the Assam Information and Public Relations Service has clubbed together journalist, sub-editor, proofreader, librarian together for promotion to the post of junior info. The scale of pay of the translator is also equivalent to that of these posts. As such, their appointments will be guided by the same rules. No separate service rule will be necessary in this regard. Separate proposal suggesting to government to empower the departmental selection committee to select translators is being sent separately. All right. The elephantine way in which the government moves. But the spirit is this only. They are same, equivalent, though with different educational qualification, but they are bracketed under the same group with the same pay band, same pay scale. Responsibilities would be similar. Translator also has to do many things. Librarian, I mean, for a junior information officer, translator would be as effective as a junior.
Job profiles are different for translator, my lord. Translator has to translate, and my lord, librarian has to manage the library.
The single judge thereafter said.
Question is, my lord, whether a service rule, if a service rule provides a thing, my lord, that can be tinkered by way of, my lord, a government notification. There is no government notification.
Necessarily, not that, but that question would not be relevant here. And there is a consuetudinal practice of including translators in such appointments. When I say consuetudinal, it is the customary force which is passed into the law.
My lord, in fact, my lord, the honorable single judge has also held that there has been past practice.
That's
That
what
is
I'm
one of the
saying.
grounds, my lord.
That's what I'm saying.
My lord. On that, my lord, I'll take your lordship to two decisions, my lord, of the Honorable Supreme Court.
Yes.
Whether, my lord, the service rules can be tinkered with by, my lord, government notification. Here there is also, my lord, no government notification, only communications, two communications from the director to the government. The first one is, my lord, 1997 4 SCC 753, D. Stephen Joseph. Your lordship may kindly come to paragraph 5. I will not, my lord, trouble your lordship with the other narrations. Paragraph 5, if your lordship permits, I will read, my lord. It appears to us that the state government is laboring under a wrong impression as to the applicability of the past practice as indicated in Suresh Nathan's case. My lord, this is the case what the Honorable Single Judges, my lord, relied on. Suresh Nathan.
Yes.
The court in the said decision has only indicated that past practice should not be upset, provided such practice conforms to the rule for promotion and consistently for some time past, and the rule has been made applicable in a particular manner. In our view, the decision in Nathan case only indicates that the past practice must be referable to the applicability of the rule by interpreting it in a particular manner consistently for some time. Any past practice dehors the rules cannot be taken into consideration as past practice consistently followed for a long time by interpreting the rule. It may be indicated here that a similar question also came up for consideration before this court in M.B. Joshi's case. The decision in Suresh Nathan case was distinguished in the facts of the case that it was indicated that when the language of the rule is quite specific, that if a particular length of service in the federal post together with the education qualification enables a candidate to be considered for promotion, it will not be proper to count the experience only from the date of acquisition of superior educational experience, only from the date of acquisition. So, and my lord, the other decision I'd like to rely is, my lord, 1998 8 SCC 469.
Just yes.
My lord, this case of K. Puttaswamy. Small judgment. Paragraph 3. The short point on which these appeals must succeed is that the tribunal fell into an error in taking the view that since the government had indicated its intention to amend the relevant rules, its action in proceeding on the assumption of such amendment could not be said to be irrational or arbitrary, and therefore the consequential order passed have to be upheld. We are afraid this line of approach cannot be countenanced. The relevant rules, it is admitted, were framed under the proviso to Article 309 of the Constitution. They are statutory rules. Statutory rules cannot be overridden by executive orders
That's
or
right.
executive
That's a good principle, but we are referring to this on page 4. The service may also include any post equivalent. In caterment, you're right. This judgment will be in your favor.
It has not been encountered, my lord.
That's right.
Yes.
That's right. It has not been in.
My lord.
But any post equivalent to a post, and this equivalency, the government believes that it is equivalent. Payment is equivalent. Same bracket when you are appointed, advertisement same.
It's not the government which believes it, my lord. That is where the problem is, my lord. It is the director who believes. Where is the, my lord, where does the government say that, my lord, this is equivalent?
Super technically.
This is not technical, my lord. This is not technical.
Correct.
Only the, my lord, director is trying to help the, my lord, respondent number 7. And, my lord, the government has not passed any order.
No. It was not personal kind of a thing. All translators would have been.
Earlier, my lord, yes. That's why, my lord,
all translators. Therefore, this malafide cannot be alleged.
No, I am not alleging malafide, but then fact remains, my lord. The communications, my lord, reveal itself, this itself, my lord, that
And there was only one post of junior information.
No, in fact, my lord, there are 2-3 posts.
And you did not qualify for any.
No, in fact, my lord, only one person was appointed. Only, and but there is an interim order, my lord.
Criteria of promotion is seniority.
And my lord, there is a
Come merit.
Seniority.
We have done the same.
And the translator was found to be senior.
Yes.
No, my lord, this
Yes,
is not
yes,
a.
yes, yes. No, no.
My lord, the appointment orders, they have joined on the same date,
And it is in the same gradation list.
same date, my lord, that's my
Same
lord.
gradation list.
No, so far as
bracketed
gra-
together.
so far
Equivalence
as-
can be, what is the index on which you will decide that a particular service is equivalent to the other?
My lord, in fact,
Suppose in engineering department, there are normally two wings. One is technical, the other is general manpower. Now both, they meet at one point. Right? So therefore equivalence is decided there. You're right, it has not yet been included. That decision is not there. It's only the contemplation of the government.
Right.
Agreed. But 2(1)(a), whether we would be justified in tinkering with this appointment
my lord,
and with the single judge's order, the view is not perverse.
my lord, rule 3(1)(a), that has to be, my lord, that cannot be read in, my lord, isolation. This has to be read, my lord, along with the other provisions of the rules, my lord.
May also include.
A and B.
So this is one by a decision which would be very specific, which
My lord.
would be ironclad.
My
The
lord.
government has come out with a notification,
lord.
no arguments. And any post equivalent to a post in any one of the cadres mentioned in sub rule 1.
My lord,
This takes care.
yes, my lord, that is a sub rule 2. Now, your lordship will, that is a sub rule 2 of rule 3. Rule 3 is, my lord,
What is, it can't be held to be a redundant or just
no, I'm not saying it is redundant, my
any
lord.
post equivalent to a post in any of the cadres mentioned. For
Any
this-
of the cadres mentioned, my
for
lord,
this,
that is
the government doesn't have to pitch in.
no, my lord. No, your lordship
Doesn't have to pitch in.
is right, my
It
lord.
is encadrement.
Your lordship is right, but then your lordship will say this sub rule 2 is a, my lord, is a sub rule of rule 3. Rule 3 speaks of, my lord, three classes, 1, 2, and 3. And my lord, the petitioner, I mean the appellant and the private respondent, they are not in, my lord, in these cadres. They are not in class 3. They are being promoted to class 3. Because, my lord, in class 3, junior of, information officer is, my lord, placed in class 3. So we are not in that class, my lord.
You are in which class?
We are not in any.
We are not in any class, my lord.
Rule 11 provides since that we get promoted to JS.
So, my lord, my lord, sub rule 2 has to be read, cannot be read in isolation. It has to be read with, my lord, sub rule 1.
See, with the addition of subclause 2, A and B, it seems that this this list at class 3 is not exhausted.
Then your lordship will also read along with the, my lord, sub rule Roman 5 of rule 11 promotion, my lord. There it is clearly stated, my lord, the translators are not included. My lord, rule 11 starts at page 9.
Very
Promotion.
faulty framing of rules. These are inexperienced way of drafting the rules.
Your lordship is right, my lord. Your lordship is right, but then we have to go by the, my lord,
Cannot
rules
be
that.
left so open-ended.
That's why, my lord, they are trying to get the amendment. That is fine, my lord. But till that amendment is made, my lord, I have to be guided by the rules in existence, the extant rules.
Difficulty. All right, Mr. Chaudhary.
Hello, one more letter, my lord. Your lordship will kindly come to page 220.
My lord, just one sentence, my lord.
Started there. Yes.
Well, I'll just refer to two documents. Oh, sorry, sorry.
One more
please,
sentence,
please.
only. My lord, your lordship will also consider, my lord, rule 19, when, my lord, the reversion can be made. That's all, my lord. These are the rules. So, these provisions your lordship will consider, my lord.
19.2.
19.2. That's all, my lord.
My lord, in the context of,
You have tried to show us the way.
Yes, my lord. I have to be giving.
That's right. Very good.
my lord, page 220, my lord. This was again a communication by the director to the government, my lord, regarding, my lord, 7 PN Productivity Commission recommendation,
Page 220.
220. Regarding that equivalence part, my lord, with reference to the government later on the
How
subjects.
can you read, Mr. Chaudhary, such document? You must be very good at reading. We
No,
can't,
my-
the copy is very illegible.
Page 220.
You have a typed
My
copy
lord,
or something?
yes, yes.
We can't, given after straining our eyes. we
And
are
I'm
not
sorry, actually, photocopy should have been. Yes. With reference to the government later on the subject cited above, I have the honor to resubmit proposal regarding recommendation of the 7 PN Productivity Pay Commission for the post of journalist, translator, sub-editor, cum proofreader and proofreader of this directorate. The post of journalist, translator, sub-editor, cum proofreader and proofreader are one rank lower than the subdivisional information and public relation officer in our directorate. These posts are at the bottom of the category of officers belonging to the same hierarchy up to the post of additional director. When director was upgraded from level 2 to level 1 in 1998, Government of Assam White Finance Memorandum enhanced the scales of pay in the posts up to the rank of district information and public relation officer, depriving non-ministerial posts of the benefit of pay enhancement. These posts were left untouched, placing in the lower pay band with lower grade pay and compared to their counterparts of the other level of directorate like agriculture, animal husbandry, etc., etc. Now, if a lordship would kindly come to the last column, my lord, information and public relation, journalist, translator, editor, come, etc. Please come to the right hand side, column number 4, my lord. The nature of job of this feather cadre is almost similar with that of the next in the hierarchy. As regard Department of Information and Public Relation, nature of job of this feeder cadre is almost same with next higher post of so and so, and as such coverage, meeting, events, various public,
They have
etc.
bracketed together for
Yeah.
pay revision.
For the pay revision.
This equivalent, but
Equivalent.
Mr. Chaudhary's argument is not misplaced.
Yes, no, there is no,
He's
there is,
absolutely right.
there is no
That-
encadrement as we understand in, but my lord, I'll be covered by the first clause. It's an equivalent post. And my lord, the government's affidavit is very important, my lord. And my lord, page 222 for a moment, my lord. Page 222. Now, this is a notification by the finance department, my lord. In exercise of the power conferred by proviso to Article 309, etc., etc. Kindly see, my lord, they're all grouped in the same thing, my lord. My lord, one of the indicia, whether a post is equivalent, pay scale is one of the indicia, my lord. As has been.
Otherwise, also at all places you have been bracketed,
Yes,
just that
yes,
your
yes,
name
yes.
doesn't follow.
And my
there is
lord,
no
affidavit of the
separate
government,
notification.
affidavit of the government, my lord, at page number 114, paragraph 6. Page 114, if a lordship would kindly come to the subpara, the persons holding the post of translator were getting promotion to the post of junior information officer since decade as and when there were vacancies. Accordingly, with such a long history of promotion,
No, that's all right. That gets it. That would not, Suresh Nathan is not the guiding factor now.
Nathan says two things. If there is a conscious past practice, which is in, and secondly, my lord, it must be in tune with one of the possible interpretation of the rules. If two ways a rule can be interpreted, if it can be matched with one of the interpretation here, my lord, that a equivalence of the post.
My lord, may I take 1 minute, my lord? I'd like to place one decision, my lord, one more
Yes.
decision. That is, my lord, 1997 6 SCC, page 766, my lord, when erroneous promotion is given, my lord, by misinterpreting the rules, relevant paragraph is paragraph 8, my lord. We are, however, unable to accept the submission made by the learned counsel.
Which paragraph are you reading?
Paragraph 8, my lord. We are, however, unable to accept the submission made by the learned counsel appearing on both the SLPs. Even in some cases, erroneous promotions have been given contrary to the said service rules, and consequently, some employees have been allowed to enjoy the fruits of improper promotion. An employee cannot base his claim for promotion contrary to the statutory service rules in law courts. Incorrect promotion, either given erroneously or by the department by misreading the said service rules, or such promotion given pursuant to a judicial order contrary to service rules, cannot be a ground to claim erroneous promotion by perpetrating infringement of the statutory service rules.
Mr. Chaudhary, that is, Mr. Chaudhary, this is the law. One wrong cannot, cannot be succeeded by another wrong
Fine.
decision. That
And my lord, had the
contextual reading of all this make us think that it was not beyond the competence.
my lord, if my lord, the government had taken that post to be uncovered, what was the requirement of this communication?
So we leave that, notification regarding encadrement.
Right.
We are talking about the other clause, any equivalent post. That encadrement, you are absolutely justified. We could not have agreed more. This is only in the contemplation.
I am grateful, man.
But then, a difficult case for you, nonetheless, the appeal is dismissed. Deep respect. Appearance slips, please. Appearance slips. Yes. No. Mr. Mishra. Mr. Mishra, the challan thing.
Yes, well, by order dated 22nd of July, your lordship asked them to bring to your lordship's notice what are the
Yes.
procedure that has been followed.
Advocate to.
So they should file an affidavit with a copy to me. If they hand,
File an affidavit and give a copy in advance to Mr. Mishra.
yes,
So we are only adjourning it. We are
Mine,
not asking you to
mine,
do anything.
mine.
All right.
Mine.
But remember to bring that, serve it on him personally. Don't wait for him to come to court. Have it served to him at his residence also. Right? Okay. As break for on behalf of the respondent, notify. After 2 weeks,
my lord, let it be in the first week, any date.
first week, we are slightly tied up
Second
for
week,
very second.
second.
11-9.